Hello and welcome to Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'll be joined by Laura Windsor, the chair of our Labor, Employment, and Immigration practice, to discuss key considerations for employers in 2021. How are you doing today, Laura?
I'm doing great, Brydon. Thank you.
Thanks for joining us on the Benefits Companion.
Absolutely. My pleasure.
So with a new administration in place and a new year, and as we're emerging from the pandemic, what are some key considerations that employers should be thinking about in 2021?
Well, gosh, Brydon, we have been watching so much that we anticipate coming out of the Biden administration. Throughout the entire campaign, Biden had proposed numerous employment issues as at the forefront of his policy objectives. So I think in the next year or two, we can expect probably 6 very major employment law initiatives. The first one is we can anticipate a push at the federal level for expanded civil rights laws, largely to expand Title VII of the Civil Rights Act to affirmatively include gender identity and sexual orientation. The second item, we certainly can anticipate federal OSHA plans for COVID-19 return to work protocols, as well as certain vaccination policies that have been a sore subject for a lot of employers, even in the last couple of months. The third item is an anticipated push for crackdown on non-compete agreements, restrictions on workers' ability to work for other employers, particularly low-wage workers. The Biden administration has been very firm in its commitment, as has been reported in the news, to a $15 minimum wage. I think we will see that percolating throughout the administration in at least the first 100 days, but certainly before, going on into the first year of the administration. The fifth item that we anticipate is a crackdown on independent contractor misclassification. And then the sixth, but certainly not least, is a lot of new pro-labor law, labor union legislation that we anticipate. So those are the 6 things that are kind of on the forefront, some of them certainly more prevalent and hot button topics than others.
Yeah, I mean, that's a lot. That's a big list, very significant items, 6 items. So what, if you had to narrow it down to a few of them, to 3 of them, what would be the ones that are really the most important for employers to consider in 2021?
Well, I think, COVID is obviously going to remain with us in 2021, as much as we would love to put it in the rearview mirror. So I think that the OSHA plans for COVID-19 return to work protocols and vaccination policies is going to be a hot topic. For those of you listening in Virginia, as you know, we already have a comprehensive workplace safety law from the Virginia Department of Labor and Industry. So if you're in Virginia, I hope you've read those. There are similar laws in California, Michigan, and Oregon, but really the federal government deferred to the states to come up with their own workplace safety laws, which, given that I only listed 4 states that actually have such laws, I think we can see that the federal government does need to step in. So now that Marty Walsh has been confirmed by the Senate as labor secretary, he has stated that one of his first objectives is to have some kind of federal OSHA standards, at least for certain high-risk employers. So one of the things they did, they just announced a national emphasis program from OSHA. That's really a first step, but it's pretty aspirational. It also really only focuses on hospitals, home care, and like supermarkets, and doesn't even really put into place a lot of safety measures. It really just talks about positive test reporting, how to make complaints if you feel like your workplace is unsafe, and provides for OSHA inspections. So I do think that we will and should see some further guidance from the Department of Labor and specifically OSHA on some more kind of federal, very broad brushstrokes safety protocols for COVID. And then along with that, of course, a lot of employers are really struggling with vaccine policies. Do we do an incentive program? Do we do a mandatory vaccination program? And frankly, the federal government has been pretty quiet on it. The EEOC has issued some very basic informal guidance on mandatory vaccination policies, largely just to make clear that if you're an employer, you can do a mandatory vaccination program, but you have to make reasonable accommodations for people who have disabilities or sincerely held religious beliefs that will prevent them from getting the vaccine. So I'm hopeful, a lot of my clients are hopeful, that we'll get some additional guidance from the EEOC or the Department of Labor on kind of how to manage these vaccination programs at the employer level.
Yeah, I know some employers also are concerned about privacy issues regarding, COVID screenings and vaccinations. And I think as far as vaccinations, it's pretty much the same as when you have a flu shot in the office. And the health screenings, really are treated as employment records. The healthcare provider that does the screening is a HIPAA-covered entity and has their own issues. But those are also considerations as employees return to the office and as employers work to provide a safe workplace.
That's right, for sure. It's a tricky subject because we also want to know which of our employees have been vaccinated. And you can ask yes or no, have you received a vaccination or not? That is not, the EEOC has said that is not a medical inquiry. So you can ask that question. But you want to be careful of getting the no because I have this huge underlying health condition.
Right. So what are some other issues that employers should be considering?
I really think that one of the next big ones that we'll see is an additional push on traditional labor laws. One of the key policy objectives of the Biden administration, and supported by the hugely pro-labor new Secretary of Labor, Marty Walsh, is to promote and protect labor unions through what's called the PRO Act. This law actually just passed the House and is now heading to the Senate. It passed the House pretty handily. It's really not clear whether it's going to have enough votes in the Senate to pass. Last I checked, I think there were like 45 backers of the bill in the Senate. But this is a huge labor bill. I mean, it is something we haven't seen probably since, the 1930s or 40s. It would remove the right to work state laws and mandate that employees who work for a company that has a union and are covered by a collective bargaining agreement would have to participate in and pay dues to that union. It would require the reporting of what's called persuaders. These are people who advise the company on union avoidance strategies, i.e. sometimes lawyers. They would have to be reported to the National Labor Relations Board as, quote, persuaders. It also would prohibit employers from even meeting with employees during a unionization campaign to discuss with them all of the benefits of not being a union shop. It would also provide independent contractors potentially with the right to organize. And I think what's scaring a lot of companies is that it would expand this concept of joint employers so that if one subsidiary of a company is unionized, that collective bargaining unit could extend to other affiliated companies. And that obviously is causing a lot of concern, particularly among some of the larger companies that maybe have small unionized workforces, but as a whole, they're pretty limited in their union activity. So as I'm sure you can expect, this is a top priority of the AFL-CIO, which has huge lobbying power. And as I mentioned, the new Secretary of Labor, Marty Walsh, comes from a very pro-labor background. And so I think this is going to be one that, frankly, we'll see probably debated in the Senate within the next 90 days.
I mean, that sounds like one of the most significant changes in labor law in a generation.
Absolutely. In at least a generation. Absolutely.
And for employers in Virginia, states like Virginia that are right to work, significant changes if this becomes law.
That's correct. So that's definitely a big one. I think, again, kind of staying in this concept of pro-employee legislation and pro-employee activity. The other one that I really kind of see on the forefront is, a push towards eliminating what's called employee wage theft. It sounds pretty scary, but what it really is referring to is the independent contractor versus employee relationship. A lot of companies use independent contractor models. Again, for those of you in Virginia, we just had a law that was passed and went into effect in July of 2020 that prohibits employers from, well, I shouldn't say prohibits employers. Employees are presumed to be employees, and the burden falls on the employer to demonstrate that they are truly independent contractors. And that's a really hard test to meet. But as a federal level, I think one of the objectives of the Biden administration, and again, under Marty Walsh, will be to have a really stringent independent contractor test, similar to the one that California uses, which is called the ABC test. Under the ABC test, a worker is considered an employee and not an independent contractor, irrespective of any agreement you might have, unless that worker is totally free from the control and direction of the company in the performance of their work, the worker performs work that is outside the usual course of the hiring company's business, and the worker is customarily engaged in an independently established trade, occupation, or business. So as you can see, I mean, this kind of eradicates the concept, if passed, of, hey, I've got, Joe's a consultant. He works here. He's a 1099. That concept is going to be pretty much eviscerated if that legislation gets any traction.
And I think there's a significant risk for employers because there's already a misunderstanding of what it means to be an employee or independent contractor. I encounter employers often that they say, well, we have an independent contractor agreement.
Right.
We've agreed, and not kind of understandably, they think that means the person's an independent contractor when really it's a facts and circumstances determination. And so if we're already at that level, if we then have this legislation, employers really have to be educated on what it means to be an employee or an independent contractor.
Yeah, and I think, Brydon, that's a really good point. And I think also thinking about the consequences. I mean, the consequences of misclassification are huge. You could be getting a visit from the IRS. You could be getting a visit from the Department of Labor. If you're an independent contractor, the company has not been paying into a workers' compensation fund. It has not been paying into an unemployment compensation fund. I know from the Virginia legislation that a study was conducted prior to our current law that found that the Commonwealth of Virginia loses $28 million a year in tax revenue because people are classified as independent contractors. And if there's one thing I think we can all learn is that the government always wants its money. And so if we can, if we can eradicate that independent contractor model, you're getting more money into the unemployment compensation fund. You're getting more into FICA. You're getting more into Medicare. You're getting more workers' comp. And so, the risks to an employer for a misclassification is pretty significant. And then, of course, here in Virginia, we also now newly have a private right of action for people who believe they've been misclassified. They can sue on an individual basis and seek to recover any damages that they experienced or suffered by virtue of being misclassified. So imagine if you're an employee and you get employer-paid health benefits, but because you've been misclassified, you're having to pay for your own health benefits. Well, that's a form of damages for your misclassification.
Right. Well, Laura, thank you so much for joining us on the Benefits Companion. If listeners have any questions or suggestions for future episodes, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.